The next matter to come before the court this morning is Lisa Traylor versus Timber Top Inc. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, I'm keeping the clock this morning. I can keep you apprised of the passage of time. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. Good morning, Your Honor, counsel. First, I'd like to begin by thanking both the court and opposing counsel for the accommodation that the court and counsel agreed to reschedule this due to a family emergency. I appreciate the court's consideration and opposing counsel's courtesy. My name is Andrea Whitaker. I represent the plaintiff in this matter, and I would like to reserve optimistically 4 minutes for rebuttal. I think the heart of this appeal is about what is required by notice pleading. Notice pleading requires that a claim set forth only those operative facts sufficient to give fair notice of the nature of the action, and a complaint may contain allegations from which an inference may be drawn. The facts that were contained in this complaint are that Nicholas Lowell Schaefer resided at Timber Top Apartments with his mother and legal guardian. That from August of 2010 until July of 2013, there was a written lease on which Nicholas was listed. Nicholas was a minor with autism. The Timber Top, the defendant in this matter, failed to plan for water storm runoff. Timber Top failed to maintain its property in a safe condition. The dangers of Timber Top's property were foreseeable to Timber Top, and that Timber Top failed to warn the guardian of the flooding and the water control dangers, and that Nicholas drowned at Timber Top during the pendency of the lease as a result of these failures. We have appealed the trial court's decision that the complaint was both insufficient and that the dismissal should have been with prejudice.
Are you claiming that because the son was autistic, the landlord had a higher duty to police the grounds in order to protect the son against danger of any kind?
There were several allegations included in the complaint. There was a regular negligence with a regular duty claim. There also was the heightened duty of care negligence. And for that, I cited to the court that the Ohio Supreme Court has recognized in Bennett that there is, to a greater degree of care to children and those youthful persons generally, due to their inability to foresee and avoid the perils that they may encounter.
But you have said that this child was autistic, implying that because he was autistic, he was owed a greater duty of care than would be owed to children generally.
No, I believe it is the same duty of care, the heightened duty of care that provides for him. He was a minor, but he was older than, he wasn't 4 or 5. So the fact that he was autistic and a young teenager brings him into that heightened duty of care with the youthful general that the Supreme Court noted. In terms of the court's dismissal of the ordinary negligence claim, it dismissed the wrongful death claim as a result of the ordinary negligence dismissal, so I'll begin with that. The trial court determined that the only ordinary negligence claim that could be pursued was a violation of the Landlord-Tenant Act, and then concluded that no such allegations were sufficiently pled in the amended complaint. However, Ohio Revised Code 532101 does provide for the obligations of a landlord, and while that code was not specifically pled, the facts that were pled were sufficient to allege a violation of that, and that's what's required by notice pleading. The code requires that a landlord do whatever is reasonably necessary to keep the premises in a fit and habitable condition and keep all common areas of the premises in a safe and sanitary condition. And the amended complaint makes the allegations that the Timber Top did not maintain its facilities in a safe condition, and it actually goes further by alleging the manner in which the failure to maintain was accomplished or not accomplished, and that was for failing to provide for water conditions and to prevent, repair, and warn of those dangerous conditions. It alleges the necessary causation, as well as the fact that those dangers were foreseeable. And the defendant, the appellee in this case, makes an issue of the fact that there was no claim of notice. I think first, on the Landlord-Tenant Act, it is a per se violation. It is per se negligence if there's a violation of the Landlord-Tenant Act. And I've cited Mann versus Northgate Investors, that even if notice hadn't been provided, negligence is presumed by the violation of the statute. But second, and more importantly, the complaint does allege constructive notice by alleging that the dangers were foreseeable.
You say it's presumed. It's presumed based upon what evidence? The physical, the testimony about the physical condition or whatever caused the accident?
A violation of the statute, a violation of the duty imposed by the statute is per se. And the allegations in the complaint that the property was not maintained in a safe and habitable condition, is a violation of the statute. And so therefore the duty is presumed to have been violated. It's a per se violation. If at trial or the summary judgment. Yes.
You're not suggesting it is a presumption that carries through beyond the trial in evidence to the contrary?
Absolutely not. Absolutely not. This is just for the initial notice pleading requirements of Rule 8. And certainly for most of this, I wouldn't respond to a summary judgment motion with just the allegations in the complaint. This is just for whether or not it alleges enough to survive the Rule 12b-6 motion to dismiss.
So if I filed a complaint that said, defendant owes me a duty, defendant breached that duty, defendant's breach caused me harm, is that sufficient to survive a 12b-6?
Well, I don't think we have that case here.
Oh, okay.
I think in this case, we addressed what the duty was. We addressed how the duty was violated. The complaint, I say we, Ms. Traylor's initial attorney, indicated and pled causation and indicated and pled specific injury. So I think in this particular case, the complaint goes much farther than Your Honor's hypothetical.
But are we talking about facts? It seems to me that I recall, and forgive me if I'm misreading this, but it seems to me that there was a challenge that the allegations of the complaint were legal conclusions rather than factual.
Right, and that was the allegations, and that was some of the trial court's finding. But those facts that I laid out, the specifics about that there was a lease, that he lived there, that he was on the lease, that the property wasn't maintained, the discussion about...
When you say the property wasn't maintained, is that specific enough?
I think it is specific enough when it talks specifically about the manner in which it wasn't maintained.
And that was in the complaint?
Yes, it mentions in the complaint that there were flooding and water control dangers at Timber Top, and those were not adequately cared for, prevented, and maintained. So I think the complaint goes farther than just saying the property was dangerous. It goes into specifics about what the problems were and what was not handled correctly there. So I think that the complaint does meet Your Honor's concerns in terms of that. I'm going to try to be a little quicker here. I would say that the same argument can be made for the common law premise liability. Again, the complaint specifically alleged what was not done, what the duty was, what the harm was, and that causation was there. I think one of the most clear examples of the essence of Rule 8 not being recognized by the trial court is its handling of the breach of lease causation complaint. And that is it dismissed simply because the initial attorney failed to include the allegation shall be realleged here as in done in the previous sections of the complaint. And because of that, the trial court said that that particular count only had conclusory statements. Certainly, that is the best practice, but a dismissal based on the failure to include that sentence that is realleged, I think really does miss the point of the notice pleading of Rule 8. I will very briefly touch on the issue of the dismissal with prejudice. I think it's clear that this dismissal, especially I think the breach of the lease is the best example, was not on the merits. The facts, actual operative facts, were contained in the complaint. Whether they could have been more artfully pled, whether they should have been more interwoven with the specific counts, certainly is a subject up for debate. But the facts were contained in the complaint that support the notice pleading requirements, and because of that, a dismissal with prejudice was unduly harsh here. The dismissal with prejudice is disfavored simply because the court prefers a resolution on the merits, and they're held for cases where the parties have been irresponsible, stubbornly disobedient, or dilatory. Here, the first motion to dismiss was filed just 2 months before the dismissal with prejudice. Counsel and the plaintiff had attended every hearing, had been very active participants. The reason it was 6 months after the complaint was filed is because it took 4 months to get service on the defendant. Service was eventually made at the exact same address.
You're just now reaching that 4 minutes, continue or reserve.
Thank you, I appreciate that, Your Honor. So there's been no delay. There's been no dilatory or stubborn or egregious conduct that would give rise to the need for dismissal with prejudice here.
Was there anything in the record that would suggest that the dismissal is in the nature of a sanction?
There wasn't anything in the dismissal. The court's order seemed to note its court's displeasure with the fact that it didn't believe the amended complaint addressed all of the issues in the original dismissal, but there was nothing in the order that indicated that this was a sanction. And I will allow my opposing counsel to go.
May it please the court. Chris Cotter with Retzel and Andress on behalf of Appellee Timbertop Inc. The amended complaint was properly dismissed with prejudice. Appellant was given a second opportunity to file a pleading that contained operative facts and failed to do so. And this was on the heels of Timbertop filing a motion to dismiss the original complaint, in which it argued the complaint was insufficiently pled and stated a claim that does not exist under Ohio law. The trial court, rather than dismiss the original complaint, allowed appellant to file an amended complaint, ostensibly to cure the deficiencies in the original complaint. The appellant, with knowledge of Timbertop's arguments and the case law and statutory basis for those arguments, filed an amended complaint that was virtually identical to the original complaint. Some headings were added, some allegations were reorganized, the explanation for why the lease wasn't included was added to the pleading, and the date of decedent's death was added. That's it.
So I'll ask you what I asked your colleague, was the dismissal in the nature of a sanction?
No, Your Honor.
Dismissal with prejudice?
In fact, the first action that the trial court took to dismiss or to deny Timbertop's original motion to dismiss and allow plaintiff to file an amended complaint, I would argue was a lesser sanction to permit appellant to have a second bite at the apple. But by the time appellant filed their amended complaint, which is virtually identical, Timbertop filed a motion to dismiss with the same arguments as before. Once the trial court determined that the complaint should be dismissed for the reasons stated in the motion, there was really nothing else to do. The trial court had already given the appellant an opportunity to cure the pleading, and it had failed to do so. and so it made sense to dismiss the complaint with prejudice.
Was there any flavor within the motions that were filed or anything that came out from the trial court before this injury about other avenues that the defendant could pursue to get at the allegations in the complaint, i.e. civil or motion for more particularized statement, that type of thing? Nothing, there's nothing in that.
No, not to my recollection. Appellant argues for a decision on the merits. However, the trial court's dismissal of a 12b6 motion is on the merits. The civil rules in the Ohio Supreme Court are clear on that issue. A Rule 41b3 clarifies that a Rule 12b6 dismissal is on the merits. This was not a dismissal based upon a jurisdictional defect or a failure to join parties. This was on the sufficiency of the complaint, which is a decision on the merits. If there are no other questions on that point, I'll move to the enhanced duty of care argument. Appellant has waived that argument before this appellate court. Timbertop argued twice before the trial court that there is no enhanced duty of care under Ohio law. It argued that in each of the motions to dismiss, appellant filed opposition briefs to each of those motions to dismiss and completely ignored that argument both times. The 9th District is clear on this point. If an issue is not raised at the appropriate time in the trial court, the party has waived the right to contest the issue on appeal. This is a fundamental rule of appellate review. Now, addressing the enhanced duty itself, there is no enhanced duty of care under Ohio law in this context. The Bennett case that appellant brings up is where the Ohio Supreme Court adopted the attractive nuisance doctrine. It's important to note that the duty of care imposed by the attractive nuisance doctrine is a duty of ordinary care. Quoting directly from Bennett, even when a landowner is found to have an attractive nuisance on his or her land, the landowner is left merely with the burden of acting with ordinary care. What the attractive nuisance doctrine does essentially is convert the duty owed from a property owner to a trespasser, which is no duty, to a duty of ordinary care. It does not impose an enhanced duty of care.
Do you consider dicta the court's reference to children requiring special care?
There is mention of that policy. However, there's no other case law that supports an enhanced duty of care for a landlord, such as Timbertop, to one of its residents. Bear in mind that Bennett applies to trespassers, whereas the decedent in this case was a resident. And there is case law that distinguishes Bennett based on duties owed to residents rather than trespassers. It has distinguished and not applied Bennett in those circumstances.
So the landlord would not have different levels of duties of care to the elderly, to the infirm, or to those with mental disabilities.
Correct, it's a duty of ordinary care. And keep in mind, Ohio statutory law makes it unlawful for Timbertop to refuse to rent to somebody or to discriminate based on someone's disability. That same statute states that the statute itself, the prohibition, shall not be construed to require a landlord to exercise a higher duty of care. Had the General Assembly wanted to create a higher standard of care for landlords, it certainly could have done so in that statute for the elderly or for the disabled or those with disabilities. It chose not to, and there is no case law support for a higher standard of care for a landlord for its residents. If there are no questions on that point, I'll move to the final issue, which is the ordinary duty of care negligence claim. The admitted complaint is insufficiently pled with respect to ordinary negligence, ordinary duty of care negligence. The admitted complaint contains 4 facts. Timbertop owned an apartment complex. The decedent lived at the apartment complex. The decedent was a child with autism, and the decedent drowned at the property. These are meager and scattered, unconnected facts. The remaining allegations are conclusory allegations and are repeated throughout the pleading.
Well, the amended complaint alleges that Timbertop failed to maintain the property in a safe condition, right?
Correct.
But it's a little more than just the decedent was the resident.
I would argue that is a conclusory allegation, and to the extent it's a factual allegation or quasi-factual allegation, it's unconnected to any of the other meager facts in this pleading. There's no description of what happened. There's no description of the condition on the property. There's no discussion of what was dangerous about the condition, if anything. There was no discussion, I say discussion, but no statement in the pleading about what risk was posed by this condition that isn't described in the pleading.
Well, but that, so, I mean, that's kind of the purpose of discovery, right? That the idea under notice pleading is just to give you a basic notion of what is claimed. And then you can file, for a more definite statement, you take discovery, interrogatories, depositions, etc.
It's true that the Rule 8 notice pleading standard is a low threshold, but it was not met in this case. And there's simply no connection between the condition and the drowning. In other words, Timber Top owned an apartment complex, and the decedent was a resident who drowned at the apartment complex. May establish a duty between Timber Top and the decedent, but there are no operative facts that establish the breach of duty, of what Timber Top knew or didn't know, did or didn't do, what conditions were maintained on the property. Frankly, if one were to read the amended complaint, knowing nothing else about the incident or anything else, the pleading doesn't make any sense. This amended complaint, which doesn't reach the Rule 8 threshold, is like the complaints in the West case and the Welsh case discussed in my brief. In West, that case involved the infringement of an easement. There was no allegation that the defendant infringed upon an easement. And the court there stated that absent from the complaint is an unequivocal statement of a wrongful act, which is the same here. There was no unequivocal statement of a wrongful act. Your Honor, you addressed maintenance or the failure to safely maintain. There's no allegation regarding what was maintained or not maintained, what was safely maintained, what was unsafe about it. Likewise, in the Welsh case, which involves an employment dispute, there was no allegation that the employer made a representation of conditional employment. It simply alleged that plaintiff had complied with the policies and procedures of her employment and had followed the directions of her supervisors. Likewise here, the focus is on the decedent, a child with autism who lived at the property. There are no allegations in this pleading about Timber Top, about the condition, about the maintenance. And Rule 8 doesn't ask for detailed allegations, but simply basic allegations that address Timber Top and the bare bones facts that support a claim against Timber Top in this case. If there are no further questions, I will conclude. Timber Top Inc. respectfully requests this court to affirm the trial court's dismissal of the amended complaint with prejudice.
You have just over 3 minutes remaining.
Thank you, Your Honor. I will try to touch on just 3 points briefly. First, I'd like to point out, and maybe I misunderstood my opposing counsel, but what I believe was a procedural error. There was no initial dismissal of the complaint. What happened was they filed their motion to dismiss. Ms. Traylor's original attorney filed a motion to amend the complaint. She opposed the motion to dismiss. The trial court gave her the opportunity to amend the complaint and simply found that the first motion to dismiss was moot. There was never any initial ruling or warning from the trial court that it even considered that the first motion to dismiss had merits. It simply responded to the request to amend the complaint. And in answer to your question, Your Honor, there was no warning, there was no other options. Simply the first dismissal was ruled as moot. The second motion to dismiss was filed. The court ruled that it was dismissed with prejudice. That's the procedural route that occurred in the trial court. Secondly, I'd like to address Appellee's argument that the issue of the heightened duty of care is waived. I don't think that that is in fact true. The issue of the fact that the plaintiff believed there was a heightened duty of care was raised at the trial court. It was raised in its pleadings and in the general opposition to the motion to dismiss. And it said in the motion, in the response to the motion to dismiss, that it believed that all the claims were sufficiently pled. Further, the trial court is still bound by the law to require the movement to meet its burden to provide the trial court with support for its position that the claim should be dismissed. And in this case, the movement, the appellee, provided a single case, Thatcher, that has nothing to do with the claims in this case. So even if the plaintiff had remained silent in opposition to the motion to dismiss, I don't believe that it's waived because the trial court did not hold the movement to its burden, and it was raised as a claim in the complaint. Finally, I would just briefly like to say that I would direct the court to paragraphs 7, 8, 9, 10, 3, 4, and 5 of the amended complaint. Those are actual allegations. The appellee argues again and again that the complaint doesn't address TimberTop. It addresses that TimberTop had a lease. It addresses that TimberTop did not maintain its water runoff safely. It addresses that TimberTop did not deal with the flooding and water control dangers that were foreseeable. It is specific about the dangers that were occurring at TimberTop. It is specific about that TimberTop did not address those, and it is specific in terms of causation that those dangers caused Nicholas to drown. So I think that the complaint does meet the sufficiency requirements of Rule 8. Further, I believe that the dismissal with prejudice was an abuse of discretion and unduly harsh to the plaintiff. Thank you.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision to both sides as well as post the decision on the Ohio Supreme Court website.
Thank you, Your Honors.